Good morning, everybody. This is Erick Becker. I am a partner at Cummins White, LLP, and I also head up the labor and employment practice here. And I'd like to welcome you to our webinar regarding new laws for California, Employment Law Update 2016. First of all, I want to say it's still January, so Happy New Year to everyone. We really appreciate you attending today, and we hope you find this webinar is informative and that we provide you with some information that will help you in your compliance efforts in the coming year. We have a number of different employment laws that have been adopted for California in 2016 that we're going to be covering today. There's a few changes in employment laws that we're not going to cover in great detail because they apply to few employers, but I will mention them briefly as we go through some of the new laws today. We'll also be talking about, very briefly, a California court decision that I think is very impactful for employers dealing with disability discrimination cases, as well as some new laws on the federal front that California employers need to be aware of. And finally, we'll talk a little bit about what to expect in 2016 in terms of new employment legislation or other developments in the employment field. The main topic today is going to be the amendments to the Fair Pay Act, also known as the Equal Pay Act. Really the most significant change in California law that went into effect on January 1. And so we're going to be spending a good deal of time walking through what the prior law was, what the amendments to the Fair Pay Act changed, what impact that'll have on employers, and what are some of the best practices that you need to put into place to protect your business from liability for pay discrimination lawsuits or pay discrimination claims. So that's going to be our main focus today, but we're also going to talk about some of the other new California laws, including some changes to what's called the Private Attorney General's Act, PAGA, and a safe harbor for employers to protect against PAGA lawsuits. We'll talk about some changes to school activities leave and a couple of other things as we go through our presentation today. I want to mention a couple things at the outset. First of all, if you would like a copy of the presentation today in a PDF format, please email me. At the end of the presentation, there'll be a screen with my email address for those of you who don't have it. You can shoot me an email afterwards, and we'll be glad to forward a copy of the presentation to you. Also, I want to mention, as we go through our slides today, we do have a chat function. If you have a question and would like to type it into chat, I will stop at various points and answer questions that come up on the chat line. Or, of course, at the end of the presentation, sometime today or this week, if you want to email me with any questions that you have about some of the things that we're covering today, I'll be glad to answer any questions that you may have. So, that having been said, we're going to start with our presentation, and first, of course, we have to start with the legal disclaimer. Yes, anytime you do a seminar like this, you have to say that it's not a legal advice or legal opinion, because technically, although some of you may be our clients, some of you may be not, and we can't provide any legal advice to non-clients. So what we're going to be doing today is really giving you a concise practical guide and some information on these new laws and their potential impact. But as always, you should, if you have a particular situation that comes up, you need to contact legal counsel, whether that's us here at Cummins White or other legal counsel, and make sure that you get specific advice regarding those matters and you're taking into account any relevant case law. Okay, so we're going to start with our new California laws, and as I mentioned at the outset, we're going to start off with the Fair Pay Act. So let me first talk about, and this is all under the subject of equal pay, let me first talk about this labor code section and what it previously said before these amendments went into effect on January 1st, 2016. This is in the labor code, the California Labor Code. It's section 1197.5, and it's known as the Fair Pay Act. Now, under the Fair Pay Act, when we talk about employees of opposite sex, California law for many, many, many years has required that employers give equal pay to employees of the opposite sex. So this is nothing new in terms of requiring equal pay. What the law previously said, however, was that equal pay was only required when employees of the opposite sex were performing, and this is in quotes directly from the prior statute, equal work on jobs the performance of which requires equal skill, effort, and responsibility. So under the previous version of this statute, the employee, if they were going to claim discrimination, had to show that the person they were comparing themselves to was doing essentially the same job because it requires the same skill, the same effort, the same responsibility. There was really a apples to apples comparison that was required. The previous law also required that the comparison be made between employees who work at the same establishment. In other words, they had to work in the same workplace. You couldn't compare the salary of a male employee who worked at a large facility, let's say here in Southern California, and a female who worked at a smaller facility in Northern California. And so these two requirements made it more difficult for employees bringing forward claims of discrimination because they could not go outside their own establishment in making those comparisons, and they had to show that the jobs were the same. So if, under the old law, an employer was charged with pay discrimination, there was a couple of different defenses that the employer could put forward to show that the differential in pay was not due to sex or gender. And any of these factors that are up here on the screen could be used to establish the defense. First of all, a seniority system, meaning that pay was dictated by how long an employee had been employed. The longer they were employed, the higher the pay, and therefore any difference between a man or a woman is determined simply by how long they've been working for that employer. Or a merit system, a system based on performance appraisals where people were given different pay increases based upon their performance, based upon their contributions to the business. Or by a system that measured earnings, how much somebody earns based on the quality of their production or the quantity of their production. So hey, if you don't have any quality errors in the particular product that you're responsible for producing, you get a higher pay rate. If you produce a certain number per hour, you get a higher pay rate. That was fine as a defense to any type of claim of discrimination. And then finally, there was, under the previous law, a catch-all factor. Basically said, if you can prove that anything other than sex is the reason for the pay disparity, you've got a defense, employer. And furthermore, if any of these four factors even partially explained the wage differential, as an employer, you had a valid defense. So you didn't have to prove that any of these particular factors explained the entire differential. You only had to prove that it explained part of the differential. And so for employers, you had a number of different ways to put forward a defense against an equal pay claim. And as a consequence, in California, equal pay claims, equal pay lawsuits were really not that common because most of the plaintiffs' bar knew that if they brought forward a complaint, they had some burdens they had to overcome, and more importantly, the employer had a lot of defenses that they could put forward. So our legislature decided, hey, you know, the current law just doesn't do enough to guarantee equal pay, and we need to make it essentially easier for employees to bring these claims so that we can create a more equal playing field between the genders. And so, starting January 1st, 2016, the amendments that the legislature put into place to the Fair Pay Act go into effect. And essentially what these amendments have done is make it easier for an employee to prove discrimination in pay. So let's talk through each of the amendments here. First of all, the law has now changed from requiring that the employee prove equal work to, quote, substantially similar work. Now, that may not sound like a big change at the outset, but when you really dig down, the change to substantially similar work will make it much easier for employees to bring forward a pay discrimination claim. Because substantially similar, under this new law, this new amendment, is defined as a composite of skill and effort and responsibility under similar work conditions. Essentially, it makes it a lot fuzzier. If the employee can come forward and say, yeah, we're not working in the same exact job with these same titles or even the same duties, but when you look at it as a whole, we're working under similar work conditions and we're doing kind of the same thing in terms of the skills involved and the effort we put forward in our responsibilities. So close enough. And under this new standard, chances are courts are going to say, number one, if the employer tries to defeat a claim early on in the litigation process by saying, hey, these aren't substantially similar, courts are going to be likely to say, you know what, that's not a decision we can make because there's so many different variables here. We're going to have a jury decide that. So it'll make it harder to get these claims dismissed early on in the process. And second of all, courts are much more likely to give deference to the employee's claims of substantially similar because it's very difficult to define. It's difficult to pin down, unlike equal work where you had to show that apple-to-apple comparison. The second amendment that's very important in the new Fair Pay Act is that it eliminated the requirement that the employees be at the same establishment. So under this new law, again, went into effect in January 1, if an employee, for instance, at a Fresno facility says, hey, I'm not being paid the same as somebody up in the Bay Area, in San Francisco or San Jose, who's of the opposite sex, they can still bring forward a claim. And that opens the door because obviously it's difficult to have the kind of consistency across a number of different geographic regions in California and a number of different facilities. For those of you who have multiple facilities, it makes it a lot easier for employees to bring these claims. The amendments not only make it easier for the employee to bring forward a claim, but it also makes it harder for the employer to defend against a claim. Because, as I mentioned previously, under the former version of the Fair Pay Act, you had this catch-all of any other factor. And so an employer could bring forward anything really to be able to explain a pay disparity. But that has been changed, and now the law reads that the employer can only defend under that catch-all if it is a bona fide factor, such as training, education, or experience. So that limits that factor for an employer to bring forward as a defense to only those situations where you've got training differentials or education differentials or experience differentials. And furthermore, the law goes on to say that the employer has to show that this bona fide factor is not related to sex, it's directly related to the job at issue, and it is a business necessity. So let's break that down. You must show it's not related to sex. You got to make an affirmative showing, hey, this has nothing to do with the fact that somebody's female. Secondly, you've got to show that it's related directly to the job at issue. For instance, if you condition a pay differential on the fact that, well, John's got an MBA and Sue doesn't have an MBA, but they're not working in jobs where an MBA would be helpful or an MBA would be related to the job they're performing, then you're not going to be able to rely on this factor. And lastly, you have to show it's a business necessity, and that means an overriding, note that term, overriding, okay? It overrides all other issues, and it's legitimate business purpose, an overriding legitimate business purpose that is fulfilled by implying the factor. So that's a high burden for an employer to meet. You got to show something really important, okay? Not something that we're just, pulling out to justify this pay differential. This is something that's really critical for the business. And furthermore, the amendments now add a method for the employee to defeat a defense of asserting any other factor by showing an alternate business practice could fulfill the same purpose. So if the employee can show, hey, you didn't need to apply this factor, you could have done X, Y, and Z, and you didn't, now the employer cannot assert this factor as a defense. Now the other factors that are previously listed under this law, seniority system, merit system, and a difference in measuring earnings by either the output or the quality, are still there. The big change here is that they got rid of that catch-all and now have made it much more specific. And furthermore, the new law says the employer has to prove the factor was relied upon reasonably. So you've also got a reasonableness standard that, again, gives the employee the ability to attack the reason that the employer has put forward. And lastly, the new amendments state that the factor that the employer is bringing forward as the reason for the differential is the sole reason, rather than a partial reason for the differential. In other words, you got to prove that it is the only justifiable reason for this pay differential. So again, a lot higher burden for the employer to meet to defend against an equal pay claim. So what are examples of valid factors that an employer can put forward to defend against these types of claims? Number one, a seniority-based wage scale, like we talked about previously. Number two, merit increases tied to written performance evaluations. Okay? You have to be able to show that it was a system that was put into place rather than an ad hoc, well, I think John's doing a better job than Sue, so I'm going to pay John more. Okay? Number three, bonuses or commissions based on output or sales. They have to be measurable. Okay? They have to be measurable. So, for instance, if you have a bonus program that is discretionary, at the end of the year we decide who's done a good job, and you know what? We're just going to give some people $500 and some people $1,000, and all of a sudden you've got all the women only getting 500 and all the men, or a portion of the men, getting the 1,000, you're going to have an issue. Another valid factor that you can put forward as a defense is, of course, higher pay for certifications, licensure, or degree, provided that it's tied to the job in question. And you can show that you're paying higher for prior job experience elsewhere, so long as, once again, that job experience is reasonably related to the job in question. So let's talk about what would be invalid factors under this new law. So here's some examples of what the courts are likely to find to be invalid factors as defenses to an equal pay claim. Number one, a pay difference based on differences in job title. If you're going on job title alone, under the new provisions that say if it's a substantially similar job, you got to have equal pay, you're not going to be able to successfully defend against that claim. Number two, merit adjustments without written performance appraisals. If you're just given merit increases and there's nothing that you can point to in writing that can substantiate why you gave a certain individual more than another individual of different sex, then you're going to have a problem. And a lot of employers that I run into like merit systems. You know, merit is great, but they don't do enough to document how they arrive at their decisions to make a merit pay increase different from one employee to another employee. And now with this new amendment in place, you really have to make sure that if you're doing any type of merit pay increases, it is documented and it's based on a system with objective criteria. Pay differences based on non-quantifiable performance measures. If you can't quantify it, you're going to have a difficult time proving that it's a legitimate bona fide factor. Education or training that is not directly related to the functions of the position, as we talked about previously. If you've got someone who's got an MBA and you say, well, I'm going to pay them more because they have an MBA, but it's not related to the position, that is an invalid factor. Variations in starting and subsequent salaries due to job market demand, quote unquote. Okay? If you hire somebody at, let's say, $13 an hour, and you say, hey, I've got to pay, you know, a little more than I've paid in the past because job market's getting tight, the unemployment rate is down, I need to be able to hire somebody, so I'm going to pay $13 an hour. And of course, over time, that person's going to get increases based on their initial starting rate. Okay? And then a couple of years later, you say, oh man, unemployment's way up, there's so many qualified people on the market, I'm only going to pay $12 an hour. And now all of a sudden, you've got an employee who's going to have a differential going forward in their subsequent pay rate because they're starting at a lower base. Based on these amendments, that is not going to be a factor that you can rely on in order to justify a pay differential. And finally, and this is going to be somewhat controversial, but the way this law is written, you cannot rely on a prior compensation rate to justify differences in pay. Here's what I mean. A lot of employers, when they hire somebody, find out what they were previously making, and then, okay, I'm going to give them a little bit of a bump to get them over here, but my pay decision in terms of where I start them is based upon what they were making previously. So I hire Sue, she was making $11 an hour at her former employer, hey, come over here, and I'm going to give you $11.50. But I've got male employees, okay, who come to be hired, and they were making $13 an hour at their previous employer, and oh, geez, I got to get them over here, so I'm going to hire them at $13.50 based on their prior compensation. doing substantially similar jobs. That is going to be an invalid factor to justify that pay disparity, because what the new law essentially says is that by relying on prior wage salary history, you might be adapting pay differentials that were based on sex in the first place. In other words, the reason why Sue got paid $11 at her former employer rather than other employees who are getting $13 an hour is because she's a woman. And so all you're doing is just perpetuating that wage discrimination by basing your pay decisions on prior wage rates. So, as we'll talk about a little bit more in terms of best practices, you have to make sure that when you're looking at how you set, especially starting wage rates, you are basing it on comparing substantially comparable positions to each other within your company, and you're not basing it on what the employee made at their prior employer. What are the possibilities in terms of damages if an employee can prove a violation of the Fair Pay Act? Well, the law specifically states that employees who prove that they were paid differently because of their gender or sex are entitled to back pay, the difference between what they were paid and what they should have been paid, plus liquidated damages. What are liquidated damages? They're damages that are set by statute. And the liquidated damages in this case is basically whatever they have found to be back pay, double it. So if an employee is able to prove that, hey, based on these pay disparities, I was making $10,000 less a year, and this has been going on for 5 years, so I'm entitled to back pay of $50,000, the actual damage amount is going to be $100,000, because essentially you're doubling that back pay. Now, one of the things that's very explicit in the law is that even if the employee agrees, even if the employee signs an employment contract to work at a lesser wage, that is irrelevant. They're still entitled to damages for the violation of the Fair Pay Act. Another important thing to keep in mind is that this law, like most employment laws, has an attorney's fee provision. So even if the employee is only able to show that the wage differential and the back pay they're owed is, let's say, $5,000, the attorney would be able to recover all of their fees in bringing that case forward. And in these types of cases, you're talking about a lot of discovery, a lot of statistical analysis, expert testimony. You could be looking at attorney's fees north of $500,000. So a lot of times in employment litigation, what we find is that the attorney's fees are more painful than the actual damages. But an employee who is able to bring forward a successful Fair Pay Act claim can also seek punitive damages, and those can be very, very significant. And most importantly out of all these, of course, this has huge class action potential. There have been some very significant class action lawsuits under the Federal Equal Pay Act. Most specifically, there was a Walmart lawsuit that involved hundreds and hundreds of female employees. But you could have a potential class action, and those can be very, very expensive to defend and very expensive to settle as well. A couple of other things about this new equal pay amendment that I need to mention is that the amendments now make it unlawful for an employer to prohibit employees from doing a couple of things. Number one, from disclosing their own wage rate. You can't have a policy or a practice of disciplining employees or preventing employees from talking about their own wages. Number two, you cannot prohibit or prevent employees from discussing the wages of other employees. So if you got two employees in the break room and they're talking about how unfair it is that John makes $13 an hour and we only make $11 an hour, even if they found out about John's wage rate through some underhanded mean, you can't discipline him for having that discussion. Thirdly, you cannot have a rule or a practice to prohibit employees or punish employees from asking about the wages of others. So if an employee comes in and says, hey, you know, I just think that it's maybe not fair. I've heard through the grapevine that John makes $13 an hour and I only make $11 an hour. And can you tell me, does John really make $13 an hour? You cannot prohibit the employee from asking about that. You cannot punish the employee from asking about that. And finally, you cannot prohibit employees or punish employees from aiding or assisting employees in exercise of their rights under the Fair Pay Act. So, for instance, let's say a bunch of employees have, a Facebook posting where they're sharing information about wages, or they're talking about how unfair the wage rates are between women and men at the company. You cannot take any action against those employees because that would be considered aiding or assisting in exercising rights under the Fair Pay Act. Now, as we'll talk about under best practices, a lot of employers throughout the years have had policies that prohibit employees from talking about the wage rates of others because wage rates are supposed to be confidential. Under this new Fair Pay Act amendment, you cannot have those kind of policies and enforce those kind of policies further. Now, one thing I need to clarify. The law does not create an obligation for you to disclose the wages of other employees when asked. So that scenario I talked about where an employee comes into your office and says, you know, hey, I heard John makes $13 an hour and I don't think that's fair, and is that true that John makes $13 an hour? You don't have to answer the question. Okay? You don't have to publish wage rates. You don't have to throw open the books anytime anybody requests it. You just can't take action against the employee for asking about it. Next thing under this new amendment to the Fair Pay Act is that there is a retaliation component. Retaliation has been probably the hottest area for new labor and employment cases in the past couple of years because it's very easy for somebody to claim retaliation. And now under these amendments, there's a retaliation cause of action that's been created for an employee who is discharged or discriminated against in some way if they bring an action about unequal pay. Let's say they go to the labor commissioner and they file a complaint over unequal pay and then they're fired. They can file suit for retaliation. Complaining about unequal pay. Employee comes forward and says, I don't think it's fair that John makes more than me, and there's some action taken against them. They can bring a claim for retaliation. Assisting others with disputes over unequal pay. Again, they can bring an action for retaliation even if they're not the one who brought forward the complaint or claim, but they just assisted. Retaliation for discussing wage information, retaliation for requesting wage information, all of those things can give rise to a lawsuit. And the reason why I mention this, and it's so important to be aware of, is that a lot of times what happens is you may have a situation where a week previous the employee came in and asked about John's wage rate, and then all of a sudden they do something performance-wise or violating a rule completely unrelated. They run they run their forklift into a wall. You say, ouch, you know, that's an accident, preventable, termination. Well, just keep in mind that that employee can bring forward that claim for retaliation, and the burden's going to be on you to prove that it wasn't retaliation. That wasn't your motive. And so it's going to be very, very important for you as employers to make sure that if you're going to take an action, particularly termination, after someone has complained or discussed wage information or any of these things listed on the board here, that you dot your I's and you cross your T's. Because chances are if a plaintiff's attorney gets a hold of it, you're going to be put on trial, and you're going to be the one that's going to have to prove that it was a legitimate reason for taking that decision to terminate or discipline or any other action. Okay, so let's talk about best practices for dealing with this new Fair Pay Act claim, this new Fair Pay Act amendments. Okay, number one, it is very important for you as an employer to audit your current pay rates and your job descriptions so that you can analyze any disparities in substantially comparable positions. So especially for those companies who have multiple facilities, you're going to have to do a pretty thorough audit to look at, okay, let's take a particular job classification. Do we have a written job classification, number one, because that can help prove that there's differences in skills, abilities, and responsibilities to justify a pay disparity. But number two, do we have similar positions, even though there might be different job descriptions, sufficient enough that we would have to prove that pay disparities are justified by some factor. So you've got to audit not only your wage rates, but audit your job descriptions and your job classifications to see what jobs are going to be substantially comparable, and then looking between those jobs, do we have differentials in wage rates that really can't be justified by one of the factors that we talked about previously. Second thing I want to mention here is that if you're going to do an audit, keep in mind that if you don't maintain attorney-client privilege by having counsel involved, whether that's in-house counsel or outside counsel, all of your audit findings are going to be discoverable. So if someone brings an equal pay claim at some point down the road and your audit found that you had all of these pay disparities that couldn't be justified, that's all going to be discoverable and, of course, can be used against you in the lawsuit and can be really damaging evidence. So my recommendation as a best practice is when you do your audit, run everything through counsel to make sure that you're protected in case an equal pay claim gets filed down the road. Lastly, in your audit, don't forget about alternate forms of compensation. The Equal Pay Act, the Fair Pay Act, doesn't just apply to wage rates. It applies to all forms of compensation, bonuses, commissions, etc. So when you're doing your audit, don't just look at wage rates. Look at, hey, do we have different commission rates? And if we do, why? Is it justifiable? Are we giving different bonuses to substantially comparable positions? If so, why? Etc. Second best practice, okay? You need to audit your practices regarding setting initial wage rates upon hire. Okay? You need to look at what are we doing when we're hiring new employees? How are we basing our wage decisions? Is there a standard starting rate for everybody in that particular job classifications? Or is it all over the board in terms of their prior experience, their prior training, etc.? And if so, how do we document those differences to be able to defend if we're hiring people at different wage rates? And that involves training. You're going to have to train those people who are responsible for hiring, whether that's HR or whether that's the direct supervisors, to make sure that they're documenting all of those factors that support your pay differences, and furthermore, that you can be able to establish that those factors are legitimate, they're related to the job, and they're not going to be thrown out as invalid. Next best practice I want to mention. In your employee handbook or in your policies, there is probably some discussion regarding wage rates in your confidentiality provisions, in your non-disclosure agreements, etc. You have to take out any language that creates a rule or a practice or policy that prevents employees from discussing not only their own wage rate, but the wage rates and the compensation of others. So you're going to have to go through your handbooks and make sure that's taken out. Lastly, you need to train your supervisors regarding what is construed as retaliation under the Fair Pay Act amendments and what you need to do to avoid retaliating against employees, but more importantly, to be able to defend against a retaliation claim. In other words, your supervisors need to understand, if someone comes forward with a complaint about wages, fair pay, or someone comes forward with a complaint or requests information about wage rates of others, you need to be very, very careful if you're going to discharge or take serious disciplinary action against that employee within a close time frame. Obviously, the farther out you go, the less risk you have of a retaliation claim. But I would say, as a rule of thumb, within 3 months, that's pretty much the danger zone. So supervisors need to be aware of that, and because a lot of times supervisors can make decisions that can come back and haunt an employer, and the supervisor's like, I didn't know. You don't want to be in that position. So those are our best practices. I want to, before we move on to our next topic, ask if there's any questions that anybody wants to type into the chat regarding the Fair Pay Act amendments and how that's going to impact their business and these best practices. And of course, as I mentioned at the outset, feel free to type anything in as we're going through, and we'll certainly circle back and answer any questions at the end. Or of course, you can always email me a question. I'll be glad to answer. Okay, so moving on to our next topic. Let's talk a little bit about paid sick leave. Oh boy, everybody's favorite topic. As you are all aware, the new paid sick leave provisions went into effect last July. And for those of you who were at my seminar last year, there was a lot of uncertainty and a lot of confusion among the state folks, the Department of Labor Standards Enforcement, et cetera, as to how this law actually worked. And as a result, the legislature stepped in very shortly after the law went into effect on July 1st and passed AB 304, Assembly Bill 304, which clarified some of the provisions regarding the sick leave law. And a lot of you may be familiar with these clarifications, but I'm still finding that there exists a lot of confusion about how these clarifications impacted the paid sick leave law. So I wanted to take a couple minutes to go through what those new provisions are in AB 304 and how it can impact your paid sick leave or PTO program. The first main clarification that AB 304 put through is that it clarified or changed the requirement that if you have an accrual system for PTO or sick leave, meaning employees accrue their time off as they work, it is not given to them in one lump sum, that you do not have to follow the 1 hour for every 30 hours worked accrual system that was in the original paid sick leave law. The legislature gave a couple of alternate systems that employers can utilize. So they came up with a lot of employers, especially with PTO, who accrued PTO at a different rate than 1 hour for every 30 hours worked. And there was a lot of complaints from employers that, hey, if I'm already giving employees something that is pretty significant in terms of time off, why do I have to follow this 1 hour for every 30 hours standard? So the legislature gave a couple of alternate systems that can be utilized if your company is using accrual. First, an alternate accrual system can be compliant if your employees accrue at least 24 hours of sick leave, 3 days of sick leave, by the 120th day worked each year. And that's whether it's a PTO program or a sick leave program. So if you're accruing at a rate that allows employees to have at least 3 days off by the 4th completion of the 4th month each year, let's say you're going on calendar year, so by April 30, they've got at least 24 hours in their bank based on whatever accrual system you're using, that is compliant, even if it's not 1 hour for every 30-hour worked. So the second alternate system is you can have an alternate compliance system of accrual if new hires are given a lump sum of 24 hours of sick leave that they can use by the 120th day worked. So you've got two new alternates that you can utilize if you're using an accrual system. Second, under these paid sick leave clarifications, and just so everybody knows, we are seeing some questions showing up on the question box. So after I finish talking about paid sick leave, I'm going to circle back to equal pay. But I want to continue talking about these sick leave clarifications just to maintain some continuity here. So another change that went into effect last July is that you can have a grandfathered sick or PTO plan that allows you to use any accrual method, not just the 1 hour for every 30 hours worked. So your grandfathered sick or PTO plan is compliant if it was in place prior to January 1st, 2015, and employees earn at least 8 hours of leave within 3 months each year, and your employees earn at least 24 hours of leave within 9 months each year. So if you have a grandfathered sick leave or PTO plan, the alternate accrual systems that I was talking about on the previous slide don't apply to you. You can have any type of accrual method if that system was in place prior to 1/1/2015 and you meet those two requirements, that employees earn at least 8 hours of leave within 3 months. So you don't have to meet the standard of earning 24 hours of leave within 120 days, but they have to get at least 3 days by their 9th month each year. So that's a really, really important benefit for employers that had PTO or sick leave plans in place prior to January 2015. A couple of other paid sick leave clarifications. There was a big question under the prior law as to whether or not an employee who works for 30 days for any employer in California is eligible, or whether they have to work 30 days for the same employer. And the legislature stepped in and clarified that, and now it is in the law that in order to be eligible for sick leave, you have to work 30 days for the same employer. So if you hire somebody for 2 weeks, purely seasonal, purely temporary, they are not going to be eligible for sick leave, even if they've been working for a previous employer before coming to you. They have to work with you for 30 days in order to be eligible. Another clarification in the law, another additional way to measure sick leave pay for those people who have variable wages. In other words, whose wages vary based on some performance bonus system or commissions, etc. Previously, you had to average their wages over 90 days and figure out what their regular rate of pay was and then pay them for the hours of sick leave they're taking based on their regular rate of pay over that 90-day period. But now you could also calculate their regular rate during the work week that sick leave is taken. How do you calculate their regular rate? You take how much they earned, whether that's in hourly wages plus commission or just commission, or hourly wages plus bonus, whatever it is they earn, their total compensation for that week, divide it by the number of hours they worked, and that's their regular rate of pay per hour. And then you would pay sick leave based on that regular rate of pay for that particular work week. Much easier than having to go back 90 days. Lastly, I want to mention, when it comes to these paid sick leave clarifications, that the kin care law, a lot of you are familiar with the kin care law, which previously was in place long before paid sick leave, which said that if you grant employees sick leave, you have to allow them to use at least half of that to care for family members, whether that's children or parents, etc. Kin care has now been synthesized with the new sick leave rules, meaning that you have to allow at least half of the sick leave allotment to be used for all the different family members that people can use sick leave for under the sick leave law. So it adds, grandparents and foster parents and all sorts of other family-type members. See, as you all know, the paid sick leave law allows you to take your 3 days, your whatever you accrue, for all of those different family members, not just your own sickness. So the 50% rule of the kin care leave really is only going to apply to those companies that offer a higher level of sick leave than 24 hours. Because the sick leave law only requires that you allow people to take 24 hours to care for family members. But if, for instance, you give people 10 sick days a year, then you're going to have to allow at least 5 sick days to be used for family members. Okay, so let's go back and talk about some of these questions that you guys have posed regarding equal pay. First question, is there a cap on how far back they can go on back pay? We dispose of payroll records after 5 years. So is there a cap on how far back someone can go with an equal pay lawsuit? Great question. Thank you, Kirk. The answer is that there is a statute of limitations under the Fair Pay Act, which is 2 years. So you can go back 2 years. Good question. Does there have to be gender discrimination? Again, Kirk, thanks for the question. Could it be same-sex, paid difference amounts, putting in a claim? Again, good question. So the Fair Pay Act only applies to pay differentials based on sex. It does not apply to pay differentials based on other protected characteristics, let's say age, race, national origin, etc. So the only way someone can bring a claim under the Fair Pay Act is if they are of the opposite sex of the person or persons who they are claiming are paid more. So most typically, that would be a female employee claiming that they are paid less than male employees. But it could be that male employees claim that they are paid less than female employees, and they too can bring a Fair Pay Act. But other than differences in sex or gender, no. You cannot bring a Fair Pay Act claim forward on any other protected classification, such as sexual orientation or anything like that. Next question. Looks like it's from Jesus. Is it unlawful to prohibit someone in HR or benefits to discuss wages of others? Great question. Thank you. The answer is that the law applies to all employees. And so if someone is in HR or someone is in benefits, can you prohibit them from discussing the wages of other employees? And the answer is no. Because hypothetically, someone in HR could say, I'm being paid less than others. I would be very, very cautious for having policies or procedures that would prohibit them from discussing the wages of others. What I would say is that you could have a policy that states that if employees come in and ask HR or benefits for information regarding the wage rates of others, that HR and benefits is not obligated to share that information with other employees. Is the presentation being recorded? Yes, as a matter of fact, it is. And it will actually be posted on YouTube afterwards. So if you want a link to the YouTube presentation, you can go to our website, and our website will be at the end of the presentation, or you can always send me an email. Next question. Fair pay. Can employees be grandfathered in? Some employees have been working for us for 20 years and are making more than a new hire doing the same job. And that's a question from Jason. Thank you, Jason. So there's nothing in the law that has a grandfather provision. What you're talking about is a system that is likely based on seniority. If you've got employees who have been there for 20 years, they're obviously more experienced, they have more tenure, and there's no requirement that you would pay them the same as a new hire. Where you would have a problem, okay, is if you had an employee who had been there for, let's say, 15 years, and an employee who'd been there for 20 years. And the pay differential wasn't based upon an actual system where people got a bump every year of service or every 5 years of service. It was just, hey, Joe's been here 20 years, Mary's been here 15 years, so obviously we're going to pay Joe more. Unless you can show some real differentiation related to their job that is based upon years of service. Okay, if Joe and Mary basically are doing the same thing, they have the same level of skills, they have the same level of responsibilities, and your only reason is, well, Joe's been here 15 years, and there's no set system that gives people wage increases each year. It's just that we just pay Joe more because he's been here 20 years than Mary, who's been here 15 years. That I would be a little more concerned about. But I think you could distinguish from somebody who's been there 20 years based on their experience, their skills, their responsibilities with a new hire. Okay, next question, and this comes from Claudia. What about commission employees that are exempt and we don't track the hours? I'm assuming that would have to be related to calculating pay for sick leave. If it's not, Claudia, go ahead and type in another question. But when you talk about commission employees, outside sales employees who could be exempt, hours are not tracked. Exempt employees are paid based on a 40-hour work week. So what you would say is that their regular rate would be based upon their commission for that particular work week, okay, whatever they earned, divided by 40 hours. That would come up with your regular rate of pay for sick leave. Or, alternatively, you could take whatever they've earned in commissions over the last 90 days, divide it by, see, 90 days, that's 3 months, that would be 12 work weeks, so 40 times 12. And that you can come up with a regular rate of pay that way, and that's how you determine how to pay the sick leave. Sick leave, eligibility. This is the 30-day requirement is from 7/1/15. The question was, is sick leave eligibility the 30-day requirement based on working 30 days after 7/1/15, or could somebody be eligible if they work 30 days for the employer back in 2014? And the answer is the eligibility requirement is you have to have worked for the employer at least 30 days after the sick leave law went into effect, which was 7/1/15. Okay, looks like that's all our questions for right now. So I'm going to move on to our next slide. And of course, if you want to type in some more questions regarding any of these subjects, please feel free, and we'll address them as we go along or at the end of the presentation. I want to thank you all for the questions, by the way. They were all very good questions. And I actually debated about putting some of those questions into the presentation, but then my presentation got really big, and I worried about running out of time. So I thank you for asking those questions. Let's talk about another change, another new law. This is actually not really a new law. It's a change to an existing law, and that's the School Activities Leave Law. Those of you who have 25 or more employees are aware that you have to grant leave to employees for school activities, and that's up to a certain amount, 40 hours in a year. Couple of changes that have gone into place that make school activities leave a little bit easier for employees to take. Number one, the old law referred to children at a licensed child daycare facility. And that's been changed to licensed child care provider. So it's a little bit broader. Basically, any child care provider, whether that's an actual nursery school daycare type place, or just somebody who is a child care provider out of their home, an employee is going to get time off to deal with activities related to that licensed child care provider. Second change, the amendments now allow employees to take time off for finding, enrolling, or re-enrolling in a school or a child care provider. So employees got a 3-year-old and they want to put them into a school facility. They say, hey, I want to take half a day because I need to go out and meet with this school that I'm looking at to see if I want my kid to go there, or I need to go there and enroll them. That is a legitimate school activities that the employee can take time off for, and that was not in the prior law. And lastly, and this is probably the most far-reaching amendment, school activities leave was kind of designed for if the child had a disciplinary problem and you had to go to the school, deal with a disciplinary suspension hearing or something like that, or there was some sort of activity, Christmas play, etc. The amendments now allow employees to take time off for a school quote-unquote emergency. So let's say the employee gets called at work and they say, hey, your child's throwing up, you need to come pick them up. You have to grant them school activities leave to go pick the child up. Or you need to come pick up your child. He's a disciplinary problem. He's causing disruption in the classroom. Employee gets that call. I got to go pick up my kid. That is school activities leave. Or there's some sort of unexpected closure of the school or disaster that requires the employee to go pick up the child. So here's a question. Employee says, I got to go pick up the child. If they go pick up the child, do they have to come back to work? My answer, I think, would be no. The child now needs care, and I think that would be a legitimate school activities leave to allow that employee that time off for the rest of the day to care for the child that they had to go pick up. Now, there's limits, obviously, to school activities leave, but this broadens, and I know this happens quite a bit for employers. I got a phone call, my kid's sick, I got to go pick him up. That is, if you're over 25 employees, now something that you have to grant time off for school activities leave. Question, how do you pay sick leave for someone who does not work a regular, consistent schedule? For example, someone who works part-time in retail, they are scheduled only on an as-needed basis. So I think the answer to that question is it is going to depend upon when the employee takes time off for their sick leave, because it would be a completely unreasonable result for someone to say, I need sick leave, okay, and they're going to take sick leave hours, but they didn't work that week or something like that. So basically, you could do it one of two ways. You could take all their hours worked and all their compensation over the past 90 days, okay, and I think if they didn't work any hours in a particular work week they're taking sick leave, that would be the appropriate method for doing it. And of course, they can only take sick leave if they were scheduled, right? So let's say the employee is only scheduled to work 8 hours that week. That's the only time they're scheduled that week, and they call in sick, and they want to take 8 hours of sick leave. You can't calculate their sick leave based on that particular week of work because they didn't work, okay? And if they're, and let me just clarify something. If their regular rate of pay isn't variable, okay, if it's the same rate of pay all the time, they make 10 bucks an hour, okay, then they are going to get paid 10 bucks an hour for that 8 hours of sick leave. So it's only when they have a variable rate of pay that you'd have to calculate it based on either their 90 days worked or their compensation that work week. So for a part-time employee, if you pay them $10 an hour and they take time off, even if their hours are all over the place, you got to pay them at that rate. Question from Jen. I got cut off if it's Jennifer. I apologize. Is school activities leave paid time off? The answer is no. School activities leave is unpaid time off. Next question. Is there already a PTO accrual set in place for 2 weeks a year for vacation? Can they include sick pay when they're already accruing PTO, or does it have to be separate? Thank you, Janet, for the question. So if I understand your question correctly, okay, if you have a system in place where employees are able to take 2 weeks off for vacation, that's vacation. It is not PTO. PTO is a different system where they can take paid time off for any reason. It doesn't have to be vacation. They can take it off for sick. They can take it off just because they have a mental health day, whatever the case. Okay. If it's just for vacation, then you can't include the sick pay with it. Okay. You'd have to have, if you want to include sick pay and get credit for giving people time off to meet your requirements under the sick leave law, then you have to have it as a PTO program. Okay, and I'm sorry, Jen, I just saw that you were asking about sick leave. Yes, it's paid sick leave, unpaid school activities leave. Okay. And if I need to clarify anything on that question regarding vacation versus PTO, I would suggest you send me an email, because it sounds like that can be a little bit complicated. But generally speaking, if you classify something as vacation and they can take time off for vacation, that is not a valid PTO program, and you have to give sick leave separately in order to be compliant with the sick leave law. Oh, under school activities leave, Kirk makes a point that time off always falls under vacation or sick. The leave, basically, if your handbook allows people to take time off for school activities leave and get paid out of their vacation or sick leave, then absolutely you can allow that and it becomes a paid leave. Okay? And you can also require them to use vacation. I don't believe you can require them to use sick leave unless it is you're picking up a child because the child's sick and you're caring for them based on sick leave. Okay. Okay. Kin care. I mentioned kin care really briefly. Just kind of mentioned it in passing. The kin care law is in the labor code. If you look at AB 304, which was the amendments to the paid sick leave law, the amendments mention kin care and set forward. Kin care is basically now covers the same family members as sick leave. Okay, so the sick leave law talks about a number of different family members, children, foster children, grandchildren, grandparents, etc. Look at the sick leave law, and that is going to tell you exactly who is able to take kin care. Okay, so let's move on. There's a couple of new retaliation claims that have been created by new laws in California. First of all, most of you are probably familiar with disability discrimination, and you know that if an employee is disabled, they can request an accommodation. Employers can also request accommodations, by the way, for religious practices. And those types of accommodations have to be granted by an employer if they do not create an undue hardship. One of the questions that was out there was whether or not an employee is protected from retaliation for merely requesting an accommodation. And there was a couple of California court decisions that said no, you cannot sue for retaliation just for requesting an accommodation. Well, the legislature said that doesn't sound right. So they stepped in and said an employee has the right to sue for retaliation merely for requesting an accommodation for their disability or religion. So disability discrimination is probably, you know, the type of discrimination that leads to the most lawsuits these days, and it just adds another separate claim in a disability discrimination lawsuit because you know that everybody's going to claim they were retaliated against for requesting their accommodation. So they can sue for being denied an accommodation, and they can also sue for retaliation for requesting an accommodation. Secondly, there has been a new retaliation claim created for retaliation against family members. Here's how this works. Let's say one of your employees raises a complaint of a labor code violation. I don't think I'm getting paid my overtime. I think I'm not getting my rest periods, whatever the case may be. Not only is the employee protected from retaliation, you can't take action against the employee from bringing forward that complaint, but if they have family members who work for you, those family members are also protected from retaliation, even if they were in no way involved in bringing forward that complaint. Okay? So this is to prevent employers from retaliating through a backdoor method of, well, I'm not going to fire the employee, but his mom works here, so I'm going to fire her. Now, I believe that very few employers would actually do this, fire a family member just because an employee brings a labor complaint forward. But I could see a lot of circumstances where you might fire mom for some reason unrelated to absenteeism, performance, etc., and now that employee who complained to you about overtime can not only bring their own lawsuit, but mom can bring a lawsuit as well. What is family member? Not really defined. Okay, I would say child, parent, spouse, brother, sister, probably parent, grandparent. All those people are now protected from retaliation. Just another thing that plaintiffs' attorneys can bring forward in these lawsuits. Next new law. This may apply to some of you who use E-Verify. E-Verify, the system to check on immigration status. You can only use E-Verify to check on the immigration status of applicants who have received an offer of employment. It is now unlawful to use E-Verify to check on the immigration status of current employees or to check on the immigration status of applicants who have not received an offer of employment. So you can't run all your applicants through E-Verify. You can only run applicants once you've offered them employment, and this new law creates a $10,000 penalty per violation. So pretty serious. You want to make sure that you don't use E-Verify for one of these unlawful purposes. Last new law that I want to mention, and this gets a little bit technical, but it is something that I want to make sure everybody's aware of. Probably most of you understand that there's a labor code section, Labor Code 226, that requires that you give employees accurate wage statements. And there's there are 9 different categories of pieces of information that you have to include on the wage statement. And if you don't include that on the wage statement, an employee or a group of employees can bring a lawsuit under something called PAGA, the Private Attorneys General's Act. And a PAGA claim is not a class action claim, but it's like a class action claim. So let's say I'm Joe working at so-and-so employer, and I find out that my wage statement doesn't include my employer's address. And there's 100 other employees there, and they all get the same wage statement that doesn't include the employer's address. I can bring a PAGA lawsuit on behalf of myself and all the other employees and seek to claim the statutory penalties for providing incorrect or insufficient wage statements. And there's some pretty significant penalties that can accrue if the wage statements have been wrong for quite some time. The important thing about this new law is that it provides a safe harbor to defend against these kind of claims. Okay? So, if you ever get what's called a PAGA notice, that's a notice from an attorney saying that I have filed with something called the Labor and Workforce Development Agency for PAGA, and they send you a form letter, copy that they sent to the Labor Workforce Development Agency. Okay, oh no, I've got a potential PAGA claim. If the PAGA claim is based upon incorrect wage statements because they don't state the date of the pay periods or they don't state the employer's address, they're minor technical violations, you have a safe harbor. If you give corrected wage statements for the past 3 years to all the affected employees and you do it within 33 days of receiving the PAGA notice, they cannot sue you under PAGA. So I mention it only because PAGA claims are becoming more common, and if you ever get one of those letters, you should check with counsel immediately to see if the safe harbor applies, because you've got a limited amount of time in order to exercise your rights under the safe harbor. So that's actually, believe it or not, a good thing for employers. Yes, California actually sometimes will pass a law that benefits employers. Will wonders never cease? I want to switch now and talk about a couple of other items. First of all, there's one California court decision that I wanted to highlight. And that California court decision is a case called Higgins-Williams versus Sutter, and it involved disability discrimination. And this is a situation that comes up very commonly, and that's why I wanted to highlight it. So in this situation, we had an employee who complained that, oh, her supervisor is so mean to her, and she gave her a negative performance evaluation, and therefore she went out on leave claiming anxiety and stress. Sound familiar? Happens quite often. So she brings in a doctor's note from her doctor saying, oh, I can't release her to full duty in the same department because if she goes to work again under this mean supervisor, it's just going to create more anxiety and stress. Company said, hey, look, there's nothing here that says you need additional leave. You're released to return to work. Your doctor's saying you can't work under the supervisor. We're not gonna follow that. Okay, you need to come back to work. The employee did not come back to work on the date that the employer said, hey, you're ready, you've been released, you need to come back to work. Okay. So employee sues for disability discrimination, claiming that she was suffering from the disability of anxiety and stress. Case goes up to the Court of Appeals, and the court says the inability to work for a particular supervisor is not a disability. In other words, you saying, employee, that, oh, I can't work for the supervisor, she's too mean, she's creating this anxiety and stress, and therefore I'm protected, does not carry weight. You cannot claim disability discrimination. So that is a really, really good decision because it does come up very often. Now, if the employee is legitimately out on disability because of their anxiety and stress, and their doctor has put them out, okay, you have to still make those reasonable accommodations. But if the employee says, I can't come back to work if you're going to make me work for Janet, okay, you as an employer don't have an obligation to accommodate that because that's not a disability. Pretty important decision. If it ever comes up, I think it's something that you can rely upon to make that employee come back to work. I'm going to hold, there's a couple other questions that are in the queue. I'm going to hold those to the end. I just want to go through a couple of additional things that are coming up from the federal side of things. First of all, the National Labor Relations Board is always busy, and there's been a couple of things that they've done this past year that are very important to be aware of. Number one, the NLRB has expanded the definition of joint employer. And this is important because joint employer status can lead to liability for employers in a lot of different contexts, and it's very possible that the courts are going to follow the NLRB's lead. So this affects companies that franchise or use temporary employees where, for instance, you've got a warehouse and you're bringing in temps from a temp agency, and the temps, quote unquote, are the temp agency, quote unquote, employs those temporary employees. What the NLRB said in this decision called Browning-Ferris that came out late last year is that joint employment exists where there is a right to control the terms and conditions of employment rather than actual exercise of control. So in order to prove joint employment, you don't have to prove that the employer actually, had some control over the employment of those temp employees. You can show that there's just a right to exercise that control, and that is sufficient. The board, the National Labor Relations Board, went on to hold that that control can be indirect, meaning that it doesn't have to be directly controlling, yeah, I approve that wage increase, I approve that employee's vacation, I want you to terminate that employee. If through, for instance, the contract with the temp agency, the employer has indirect control over the wage rates paid to those temp employees, that is sufficient for joint employment. And basically, if based upon either the right of control or the actual exercise of control, and it's indirect control, the employer co-determines the terms of employment with a temp agency, for instance, then the employer is on the hook for anything the temp agency does that's a violation of the law, whether the employer was actually involved in that violation or not. Very important decision, especially for franchised employers like McDonald's, because basically what the NLRB is saying is that, hey, McDonald's, if you, for instance, prescribe what kind of uniforms the franchised employees wear, you're on the hook for anything the franchise does. Really expands potential liability. Another important decision the NLRB came down with, and this came down very, very close to the end of the year. The NLRB said that it is unlawful for an employer to prohibit recording conversations or meetings at work. Okay. In other words, employer says, I'm having this meeting with employees. Employee whips out his phone and says, I want to record this conversation. The employer cannot prohibit that employee from recording that conversation. The NLRB has said that is a form of protected concerted activity. So you got to look at your employee handbooks to make sure you don't have any written prohibitions, but more importantly, you got to train your supervisors and managers that, and remember, the NLRB rules apply to all employers, union and non-union. So if an employee whips out their cell phone and wants to record something that is a conversation having to do with work, you can't prohibit that. That's going to create a lot of mischief, in my opinion. Okay. Another thing to keep an eye out for on the federal level. Okay. You probably are mostly aware that California has a definition of what makes you exempt, and the federal Department of Labor has a definition of what makes you exempt. There's a number of different boxes that you have to check to be considered exempt. But one of those is the pay threshold. And as you know, the minimum wage went up on January 1st to $10 an hour, and so the pay threshold, which is twice the minimum wage, for exempt status in California is now $41,600. So unless you pay someone a salary of $41,600 or more, you cannot classify them as exempt under the administrative, executive, and professional exemptions. The federal Department of Labor announced last year that they are going to publish regulations to increase the minimum salary to $50,440. So that's even far above what California's minimum is, and California's minimum is far above what the current Department of Labor regulations are. So these final regulations are expected to be published sometime in 2016, probably before mid-year. So you need to keep an eye out for this, because if you've got exempt employees and they're not making $50,440, Okay? They may be exempt under California law, but they're not going to be exempt under federal law, and you're going to owe them overtime. So this is really something to keep an eye on, particularly where you've got those kind of quasi-exempt positions like, you know, assistant managers and such that are oftentimes under $50,000 a year. Okay. I want to just briefly talk about what to expect in 2016. Most of you are aware that there are a number of local minimum wage ordinances that have gone into or will be going into effect. Down here in Southern California, most specifically, the ordinance that applies to Los Angeles City and to the unincorporated areas of Los Angeles County. So if those provisions go into effect in this year and you are in City of Los Angeles or an unincorporated area of Los Angeles County, you are going to have to meet those minimum wage requirements. If you're in a city that is still part of Los Angeles County, but it's a municipality, Inglewood, Beverly Hills, Gardena, those are all cities. The county minimum wage does not apply to you. However, I would expect that in 2016, more cities, particularly in the Los Angeles County area, are going to consider their own minimum wage ordinances. City of Long Beach is already considering one, and it's more than likely the City of Long Beach will adopt a minimum wage ordinance at some time during 2016. I would expect other cities to follow suit, so look out for that in your particular city. Governor Brown basically opposed an increase in the state minimum wage, and so we do not have any scheduled increases beyond 2016. However, the legislature is dead set on passing another minimum wage increase, and I would expect they're going to try again, and we'll see if Governor Brown decides to veto it or not. There is also a push to put a minimum wage proposition on the November ballot. That would raise the minimum wage to $15 an hour at some point in the future. Very possible that will qualify for the ballot, so we need to keep an eye on that. And finally, I want to mention there was a bill that passed the legislature that would have restricted employers from using arbitration agreements to force employment claims into arbitration. That bill was vetoed by Governor Brown. I would expect that if it comes up again, Governor Brown would likely veto it again, but at some point down the road, either a new governor or maybe even Governor Brown could capitulate, and that could restrict employers from forcing employees to arbitrate employment claims. So again, something to keep an eye out for. A couple of quick questions that popped up as we were going through these final slides. Can I itemize what info are needed to be included in the pay stub? Well, off the top of my head, and this is all set forth in Labor Code Section 226, you need to show what hours the employee has worked during that pay period, what rate of pay or rates of pay the employee has been paid at during that pay period. You need to show what overtime hours they've worked and what rates of pay they've been paid during that pay period. You need to show deductions from pay. You need to show what sick leave or PTO they have accrued and available on the pay stub. You need to have the employer's address. You need to show the pay period for which the employee is being paid. Not so much the pay date, but the pay period. You need to show some sort of identification number, whether that's an employee number or the last 4 digits of their Social Security number. And I know I'm forgetting a couple of things, but those are the basic requirements. If you have a specific question about that, feel free to email me, and I'll be glad to answer your question. Lastly, exempt plus commissions exceeds $42,000 or $51,000. Would that still allow somebody to meet the exemption? So we need to keep in mind something. There is an exemption for outside sales employees. And outside sales employees are employees who are paid by commission, solely by commission, and who work outside the office, going out and making sales. The minimum salary requirements do not apply to the outside sales exemption. They would only apply to the professional exemption, the administrative exemption, or the executive exemption. And they can apply in the inside retail exemption, which gets really complicated. Inside retail exemption is basically salespeople who work inside for a retail or service establishment. They're paid at least half of their wages in commissions and earn more than 1 1/2 times the minimum wage. So if you're talking about outside salespeople, okay, don't need to worry about those minimums. If you're talking about other exemptions, commissions are always going to be counted, but keep in mind, okay, and this is a recent California decision that came out, you have to make sure that they meet that minimum salary for each pay period. You cannot average commissions over, let's say, 4 pay periods because you pay them monthly, okay? In other words, if they just get paid minimum wage in the first pay period, they're paid weekly, let's say, okay, and at the end of the month they get commissions, you are not meeting the requirements. And that leads me to something I did not mention because, frankly, no time to do it today, and it's not very common. But if you have any type of piece rate compensation system, you're paying people a certain amount based on what they produce, okay? There are some changes to how piece rate is calculated and being able to pay employees for time they spend on rest periods, and there's some safe harbor provisions. So if any of you have piece rate employees, I strongly encourage you to send me an email because there's work that needs to be done to make sure that A, you're compliant with the new laws, and B, that you take advantage of those safe harbor provisions. Most employers don't have piece rate, so that's why I didn't include it, and it is very complicated. But if you do have piece rate, I really strongly encourage you to give me a call or send me an email. So here's my contact info, phone number, my email address, our website, our employment blog, and our Twitter page. Please email me if you would like a copy of the presentation. Please email me if you have any additional questions. I really appreciate your time. I hope you found this informative. And please send me any emails whatsoever if there's additional questions that you have. Thank you very much, and I wish you all the best.